Next case will be Coloma Charter Township versus Berrien County Sheriff's Department, and Landfill Management Company. This is a full grant. It's my understanding that two advocates will share the time for the appellants. Is that correct?
Yes, Your Honor.
You'll each speak for about 15 minutes. Is that correct?
Yes.
But again, you've got to monitor your time. You have a total of 30 minutes. If one goes over by 5 minutes, it's a zero-sum game, and 5 minutes is taken out of the other counsel's argument. Do you understand that, too?
Understood.
Okay, so you'll have to do your best to monitor things, please.
Yes. Good morning, Your Honors.
Could you please shut the door in the back? Okay, please proceed.
Good morning, Your Honors. Mr. Chief Justice, may it please the Court. Robert Riley on behalf of defendants, appellants, Landfill Management Company, and Hennessy Land Company, and I'm joined by Mr. Tom King on behalf of defendants, appellants, Berrien County, and the Berrien County Sheriff's Department. As you noted, we'd like to share our allotted 30 minutes with my argument exclusively focused on the statutory interpretation issue, Mr. King elaborating on that, but also focused on the injunction and attorney's fees issues. We'd also like to reserve 5 minutes of our time for rebuttal, and I'm happy to waive the initial free fire period. In Herman v. Berrien County, the court answered the unresolved question of the scope of a county's priority under the County Commissioners Act over a conflicting local township zoning ordinance. There, the court held that in addition to the normal use of a county building, a county can cite an ancillary land use that is indispensable to the county building's normal use. In this case, the Court of Appeals erred in applying Herman in two significant respects. First, it entirely ignored Herman's indispensable use test and failed to undertake any analysis whatsoever of the normal use of the Berrien County outdoor gun range building. Second, the Court of Appeals erroneously held that gun ranges per se can never constitute an ancillary indispensable use to a county building. We don't think that's a proper reading of Herman. We believe that these errors call for this court to vacate the judgment of the Court of Appeals and reinstate the Circuit Court's award of summary disposition in favor of defendants. Stepping back from the Court of Appeals' opinion, analysis of the first of the Court's grant questions in this case is relatively straightforward, but it requires a critical, logical sequence of analysis that was established by Herman and the cases that Herman relied on. In determining whether the gun range is given priority under the County Commissioners Act over the conflicting Coloma Township zoning ordinance, we believe the court should answer the following three questions in the following sequence. First, does Berrien County have the authority to cite a county building, in this case the outdoor gun range building? Second, is the outdoor gun range building a quote-unquote county building, as that term is used in the County Commissioners Act? And third, is the adjacent shooting range ancillary and indispensable to the normal use of the outdoor gun range building? And we believe that the answer to all three of these questions is yes, but I'd like to address each of them in turn. The first is, does the county have the authority to cite a building? We believe that's well established by MCL 4611 A, B, and D, and I don't believe that plaintiffs argue or contend that the county doesn't have the authority to cite a building. The county's authority to cite a building over a contradicting land zoning ordinance, however,
if I could take you out of order a little bit.
Sure.
Assume you have a county building and assume that it's necessary and indispensable. Why isn't the building ancillary to the range instead of the other way around?
So I think that's what Herman focused on, and Herman said that the proper question is not whether the ancillary, or is not the scope of the ancillary use, but what is the normal use of the duly cited county building? That's the critical question. And I think that's where the Court of Appeals and plaintiffs are mistaken, and that they would prefer to analyze the normal use of the gun range, but Herman said we don't look to the ancillary use. We look first to the normal use of the county building. And that's why we believe that the Court of Appeals erred in this case.
Mr. Riley, I mean, this is an interesting case because the main authority is, litigation between the same two parties, and the Herman case is unanimous, and so I read it a bunch of times. I wasn't on the court when it was issued, but I'm having trouble making sense of why the word ancillary and what we should do with that. And in fact, even in the opinion, it almost, at one point, the opinion seems to define ancillary as indispensable, which I find confusing because that isn't a natural definition to me. But it was a unanimous opinion from this court that that we have to make some sense of. What do you think we do with ancillary? How do we think about ancillary?
Sure. So not to beat dictionary definitions to death, but ancillary means that it's reasonably necessary for the primary use and operations of the subject, whatever the main, in this case, the county building is. And I think that the answer to your question is resolved by language from Herman and Pittsfield that said that the power to cite a building is worthless if the county can't make normal use of the building plus something else. And that plus something else is the ancillary use, which is indispensable to the normal use. Now, Herman had a few examples of what constituted ancillary indispensable uses in that case.
Sidewalks and lights and, parking lots, but the kind of things that support the main building, right?
Sure.
But then it said indispensable to it, and, in your case, indispensable seems easier, right? Because the range is indispensable to the building that's for the range. I mean, indispensable feels easy, but ancillary feels confusing to me.
Totally agree on indispensable.
Okay.
Also happy to agree on ancillary because it's some subordinate use or some subordinate relationship to the main feature, which is the building.
Right.
So, it's a question of degrees perhaps, but, the first question is what's the normal use of the building? And then there's some subsidiary use that's the ancillary use. And I guess if the court wants to focus on one word as opposed to the other, we'd focus on indispensable. And we believe that the range is absolutely indispensable to the normal use of the building.
Does it matter which came first?
We don't believe that it does, Your Honor. Herman recognized that the sequence of construction is not dispositive, but more importantly, Herman said that the first thing we look at is the normal use of the building. That the county is taking advantage, or that a county in general would take advantage of pre-existing infrastructure shouldn't be a limitation on the normal use of a properly sited building.
But could you have the gun range without the building?
You could have a gun range without a building, yes. But in this case, they did construct the gun range building. Sure, they were aware of the existing range, but they decided that the gun range building was necessary to the operations of the county and the training of sheriffs, and the gun range happened to exist. But the dispositive question in this case is what is the normal use of that gun range building? And we believe that the range is ancillary and indispensable to that normal use. Without any further questions, I'd like to turn the argument over to Mr. King to focus on the remaining issues.
Good morning. I'd like to focus on...
Could you please introduce yourself?
I'm sorry?
Could you please introduce yourself?
Thomas King on behalf of Berrien County and Berrien County Sheriff's Department, Your Honor. I'd like to focus on two issues, what the Court of Appeals did and did not do in applying the Herman test, and then, of course, the contempt attorney's fees issue. But before I start on that, I want to respond a little bit to Justice McCormick's question. I believe that what ancillary means is used with or used in conjunction with. And if you define it that way, then it means it could be ancillary but not indispensable. Ancillary could be, for example, an office building that in conjunction with it, a cell tower was built. But the cell tower is not necessary to any of the functions of the building. So it's ancillary. It's used in conjunction with the building, but it's not indispensable to the building. And I believe that's the distinction that this court was trying, maybe somewhat artfully, but trying to make in the Herman case. So it first has to be something that is used with the building or in conjunction with the building. And secondly, then, it has to be indispensable, something that you can't do without. I want to.
So that's helpful because it's not really. It doesn't have to necessarily be secondary to it, which was the part that I was struggling with, conflicting with indispensable.
I don't believe it has to be subordinate. Right. Ancillary means used with or used in conjunction with. Mm. And then.
Can I just develop the subordinate issue a little bit?
Sure.
I guess this is kind of the cubby hole I'm putting this, the compartment I'm putting this issue in. If the county gun range building did not exist, the outdoor gun range would still serve a clear function, a clear public function. But if the outdoor gun range did not exist, the gun range building would seem to be nothing more than just kind of a meaningless pole barn-like structure. Why doesn't that suggest that there is a relationship between the two buildings, but it's a relationship in which there is a principal and there is a subordinate building, but it's the reverse of what seemingly is being argued by your side?
I noticed that in the beginning of the admonition to all of counsel, you indicated that one of the things you look at is not just this situation, but other situations that the rule of law could be applied to. And I think if you define it that way, and you say, well, the gun range, as the Court of Appeals did, that was one of their points, can be used without the gun range building, then the racetrack at the fairgrounds can be used without the grandstand, and the livestock exhibition, outdoor exhibition area can be used without the covered exhibition building, and therefore you can have the same issue over a number of things, a number of ways. I think if you apply the Herman test, which the Court of Appeals did not, the way it was set forth in this court's ruling, the first decision you have to make is, what's the normal use of the building? Once you determine that the normal use of the building in this case is to conduct firearms training, firing firearms from within the building to targets that are at various lengths outside of the building, and that you can't fire the gun in the building to a target within the building. It's so small that you find out that the normal use of this building is, in fact, for firearms training, and then the second step, that the ancillary use, the use of the range and the berm and the targets, is then indispensable to conducting the building use as it was envisioned. In addition, the buildings...
What is your response to the argument raised in one of the amicus briefs? I think it might have been the township brief, I can't recall. But they had suggested, what if you were to build a concession stand and then use that subsequently as a justification for attaching to it a sporting complex of some sort? I mean, would that... does that strike you as being compatible with the statute? And how does that differ from the situation here, except perhaps in kind?
Probably in degree, maybe. I suppose there reaches a point where the building serves no purpose but to satisfy the test. That's the point you're making. But in this case, that's not the case. In fact, Judge Duane, in the record, found that the building served two important purposes. One is, and they were both things that were raised by the township and its residents as issues of concern to them. The first was that stray bullets would leave the gun range and be a danger to the citizenry, even though the closest citizenry is a half a mile away, outside of the landfill that envelops this whole gun range. But and so it's constructed in such a way that you literally cannot fire and have the projectile leave the range area because it's deflected downward by an overhang. In addition, noise was also concerned, and the building provides dampening. The third thing it provides is, of course, absolutely inclement weather firing, and of course the other side will argue, well, don't law enforcement officers have to function out in inclement weather? Of course they do. But if it's snowing or raining heavily, you can still conduct the firearms training when it's likely that they wouldn't be conducted if, in fact, the building didn't occur. So the building is constructed, there's no doubt the building's constructed. One of the reasons was a review of the Herman decision, as the county board said, to see if it was possible, when they couldn't find a gun range, to site one someplace and comply with that decision. And they determined that if they built this building, they could solve a number of problems. One, they could comply with Herman. Two, they could increase the safety. And three, they could reduce the noise and provide all inclement weather. Those are findings of fact that have been made by Judge Duane in the court below. So because of that, we believe it satisfies the Herman test, and there's a legitimate reason for this building as opposed to the stand that Justice Markman, that you raised, which probably wouldn't have any real purpose other than to justify the sports authority. I want to go, because of my time getting short, I want to go to the second argument, even though I think I could spend another 15 or 20 minutes on what the Court of Appeals didn't do, because I don't think they applied the test at all. They simply got caught up in what was first, what was the, quote, principal use, and what was whether the range could be used without the building. And therefore they said it doesn't comply, but that's not the way the test is supposed to be. Judge Markey does I think, an amazing job in analyzing this court's opinion and applying the test appropriately. Let's talk a little bit about the civil contempt and the compensatory attorney's fees. Criminal contempt is not at issue. There was a trial. They claimed criminal contempt. It was their trial. The county was vindicated at the trial. The Judge Duane ruled that there was no intent to violate the court's order, that all witnesses were credible. There was no proof even that the injunction was served after it was entered, although there was some indication that the county attorney had signed off on it before entry. And then there was 4 years while the county was exploring other avenues that there was no violation. What the court found was there was no knowledge of the county proven that they had knowledge of the injunction. They reviewed Herman, felt that they were going to be in compliance with Herman, and they went ahead because of being in compliance with Herman, not realizing that the injunction was actually broader than required by the Herman decision. Once it had been brought to their attention by the actions filed by appellees, then they immediately stopped use of the gun range and immediately asked the court to modify the injunction because of changed circumstances, and the court ultimately did modify the injunction based on changed circumstances. So there's no proof of any willful violation. There are only two types of contempt in the state of Michigan, civil and criminal. This whole thing about pure contempt, I'm not sure what it is. I can't find it anywhere in any of the authorities that I've been able to sign. There's no citation for it. They claim, the appellants or appellees claim that pure contempt is one that's willful violation of a court order. Well, that's, if you look at the case of in re contempt of O'Neill that's cited by Judge Duane in his opinion, it's in the record, 154 Michigan Court of Appeals 255 1996 case. The standard for criminal contempt requires willful violation, and that's already been litigated, and the trial court has made a final decision, and it's not been appealed. So they try to avoid the fact that this is really civil contempt by claiming there's a third type of contempt, which really doesn't exist in the state of Michigan. In addition, Bradley Estate is closer to this opinion than you might think. In that case, the issue was failing to enforce a court order, and in this issue, it's claimed not complying with a court order. So they're not that distinct. The underlying claim in both cases is a tort claim. Negligence in that case. This case, zoning matters are enforced as nuisances per se. Nuisance per se in the state of Michigan is a tort case, and they're seeking compensatory damages. They're seeking the attorney fees that they incurred in enforcing the injunction, which are compensatory and not provided for by any statute. So because of that, we believe that that the civil contempt matter and the summary disposition awarded by Judge Duane on that should be upheld by this court. Of course, a court can enforce its orders. And we're not here to tell the court that if you can't meet the civil contempt or the criminal contempt, this court can't enforce its orders. But remember, the reason for enforcing orders is to coerce compliance with the orders. It's not penalty, it's not. So what do when you find a willful violation? You coerce compliance. And we find in this case that 4+ years the county did comply, and when it wasn't in compliance, as soon as it determined it wasn't in compliance, it stopped using the gun range. Came in before the court and said, Judge, we believe there's a reason that the injunctive relief should be modified, and didn't use it again until it was modified. So there's no really compliance issue here, and Judge Duane so found. He found that the county did not intentionally or willfully fail to comply with this order. So there's no need for the trial court to exercise its compliance requirements. If there are other questions, I'd be happy to try to address them.
Yes, before we leave, I can't find your definition of ancillary in conjunction with. Where does that come from?
It's one of the definitions in the dictionary, and I don't have the site for you.
I can't find it.
Okay. I don't think that it has to be subordinate, which is what they claim. That's the only difference between their definition and ours, that somehow ancillary means subordinate. Ancillary means...
That's the only definition that I could find.
Okay.
I'm not finding the in conjunction with definition.
Okay.
Well, you and Justice McCormick just, went through a short exchange. I'm sorry, did I? Were you?
No, I'm done.
You just went through a short exchange on some of the rhetorical terms that were being used here and the confusion surrounding some of those terms. And I understand that there's a lot of, moving parts here. But as I look back on Herman, I mean, it seems to me one of the emphasis in that case was its reliance upon McCulloch versus Maryland as kind of an analogy, developing a relationship between kind of a principal use and an incidental use. Incidental, in fact, seems to me to be the key term. And when I look at the relationship between the county gun range building and the gun range, and I ask myself, which bears the incidental relationship to the other and which does not bear the incidental relationship to the other, I'm having a hard time seeing anything other than the fact that it's the outdoor gun range that predominates, whose purpose is the dominant purpose sought to be achieved here, rather than the gun range building, which seems to me to be the incidental use. Tell me what fundamental precept I'm missing here in thinking that incidental defines the critical legal relationship that must be borne between the two structures, and to the extent that there is an incidental and a predominant structure, the predominant one seems to be the gun range, and the incidental one is the building that's been attached to that gun range, the pole barn-like structure.
And this court used the word ancillary
Well, let me use
and
incidental.
indispensable, and I'll get to that, but didn't use incidental. Incidental is now coming to the forefront because of the arguments. But there are a number of, anytime there's a significant outdoor use that's part of a building, then one can argue which one is more important than the other. Let me give you an example.
But isn't that an argument we have to go through here?
I think it's a legislative decision whether that use should be attached to the building or not. The two questions this court
Herman was
is
attempting, excuse me, Herman was attempting to speak for the legislature. We didn't just kind of develop these themes out of the ether. I mean, we were attempting to interpret what the legislature intended here.
But the county made the legislative decision that this was necessary. And so if the court is going to look again to see if the building is necessary for the outdoor use, okay, if that's the situation, then what about the small airport that has no terminal? And all of a sudden you build a terminal now. Isn't the primary and main focus of that the landing and takeoff of airplanes? And the terminal, in some airports don't have terminals up north. They just have the landing strips. And add a terminal, and now the township says, well, the county can't add a terminal to its airport because it's not zoned properly, because remember, we don't want the runway extended for bigger planes, and we don't want that use, and therefore it's subordinate. And so you can look behind the curtain and try to make that decision, but I think it's a legislative decision that the local county board makes. And this board made a decision to build that building for a number of reasons that I've set forth, and I don't think this court should second guess the need for the building.
Thank you, Counsel.
Thank you.
Good morning, Chief Justice, Justices. My name is Mike Homier. I represent Coloma Charter Township. I'm here today with Mr. Pohl, who represents the Herman plaintiffs. We're going to divide our time equally as well. I'm going to focus mainly on the land use and zoning aspect of it, and Mr. Pohl will address the injunctive relief and the attorney fees and clean up any other messes that I've made. So I want to get right to the point. I want to talk about the structure, but only in the context of the land use and zoning issue, because this has a broad implication for municipalities who I represent across the state. The reason why this is important, and it's a misnomer or mischaracterization to say things like, well, we're going to put in an airport, and then when we build a building, the township is going to come along and say, no, you can't do that. What Mr. King has just alluded to is the fact that under this court's decision in Herman, under the CCA, the county doesn't have the authority to cite that land use in the first place unless it's in compliance with the zoning ordinance. So in the example given, if you cite an airport and there are no buildings there, that is citing a land use which is prohibited under the CCA unless and until it complies with the township zoning ordinance. I want to be perfectly clear on this issue. The township is not prohibiting the particular land use. What they're saying is you have to comply with the zoning ordinance. That's an important characterization or definition here in the context of this case. And I'll give you an example, and I think I can sum this up for you in 3 words. Carolina Filling Station. Carolina Filling Station is how Judge Duane referred to this structure. It was a Carolina filling station circa 1950. It wasn't clear to anybody that it was a shooting range building. It could be anything. It could be a pole barn structure, could be a concession stand, and that highlights the problem with this. We have to start with the premise under the CCA as found not only in the statute, but by this court in Herman 1, saying the authority given to the county is limited when it comes to land uses. And in fact, they have no authority to cite land uses in and of themselves. That's what resulted in the prohibition of the use of the shooting range in the first place. That was the primary use. That is the primary use here. When we talk about land use and zoning, which I've done for nearly 20 years now, we talk about primary uses. We talk about secondary, ancillary, accessory uses. All of those are synonymous. They are a subordinate of the same property. When we talk about other unique county buildings that the county does have the authority to cite, then not only this court's decision, but also the statute is instructive, where it would be meaningless to say build a jail if you're not going to allow light poles or parking. Those are ancillary, secondary, accessory land uses. But here we have a different situation. And as the Court of Appeals found, we have the tail wagging the dog here, where the county says, okay, this was the primary land use, shooting, outdoor shooting. Now we're going to construct a building because we don't want to comply with the township zoning ordinance, which, at least subsequent to the amendments to the zoning ordinance the township made, the county never applied for a special use permit for a law enforcement training center. So what you have here over the several years are, at least in my opinion, silly attempts to avoid what should be apparent, and that is you cannot cite a primary land use and later cite an accessory structure like this shooting range building that the sheriff testified was not necessary at all, and then somehow claim, well, now we have priority over the township ordinance. Fundamentally, this makes sense too. Under the Michigan Zoning Enabling Act, it is the township zoning ordinance that has priority. So, for example, if the county had a zoning ordinance, the minute a township enacted its own zoning ordinance, it takes priority. The county is preempted from enforcing its zoning ordinance within the jurisdiction of the township. Because the CCA is written the way it is, it makes sense that the county's authority is very limited in citing buildings, and that's because it disrupts the normal course of zoning and planning, both under the Planning Enabling Act and the Zoning Enabling Act, which really seeks to avoid incompatible land uses. It's akin almost to a tax exemption case. The statute should be narrowly construed because otherwise it disrupts the normal basis of taxation. The same is true here. And this court found in Herman that the county has very limited authority here. And because of that, they only have the authority to cite buildings. So then if we look at how this structure came to be and what the purpose is, you cannot reconcile the statute and the decision in Herman 1 with what the county has attempted to do now. And that's because they still are trying to cite a primary land use. Justice Markman, you gave a great example. I'll give another one because the county actually uses that to some degree in its brief at footnote 22. And it says that the sequence of events is not dispositive. And while I don't necessarily disagree with that, this court said we're going to analyze these on a case-by-case basis. And it's certainly persuasive in terms of the timing of what happened here and when things got built in order to determine the primary versus the ancillary or secondary land use. But what the county says in its footnote is it's not unusual for a county to acquire land and use it as overflow parking while it determines how best to develop or construct a county building on that property. What the county has just stated in the footnote is precisely the restriction that this court said it could not do, and that is cite a land use if it's not in compliance with the township zoning ordinance. To further that example, let's suppose we do use land as a parking lot, and we haven't decided what we're going to build there yet, and it's overflow parking. Now we want to charge for parking, so we'll just erect a little hut where somebody can sit in there and collect money all day. It's a county-owned building. What's the primary use? Primary use is parking. It hasn't changed one bit. Same is true in this case. The primary use is outdoor shooting. It hasn't changed. They may have constructed a structure that's debatable about whether it is or is not a building, but the use, the primary land use, is no different. And all the townships.
That limitation that you're suggesting may be reasonable as a matter of public policy, but where do we find it in the statute?
Well, I think in the statute, as this court found in Herman, is the ability to cite is always semantically linked to buildings and not land uses. And in fact, nobody in this case, or since Herman, has ever challenged that the county does not have the authority to cite land uses themselves.
Does that mean in practical terms, I mean, you're going way to one extreme, let's go to the other extreme, that the county can never build a facility that includes a significant outdoor space as part of a county building?
No, that's not necessarily what I'm saying, is you have to look at what is the primary and ancillary land uses. I'll give you the example that this court used in Herman, which is lighting, parking, sidewalks. All of those are ancillary to support that.
You mentioned an airport. Can the county cite an airport?
Well, I was just using Mr. King's example of we're going to cite an airport as a land use and we're going to build buildings sometime in the future.
Okay, what if they decide we're going to build an airport, period? It's going to have hangars, it's going to have a tower, it's going to have structures, it's going to have a lot of outdoor land, it's going to make a lot of noise, it's going to make a lot of neighbors unhappy. Can they do that?
In that example, they may very well be able to do that. But the distinction here is, you know, what is the land use issue, the primary land use, and what are those ancillary uses? Let me give you another example. If, for instance, this court were to say that, okay, we're going to allow the county, and the county has argued this, we're going to build a structure, we're going to determine its normal use because we're the local legislature, and then we're going to decide where we can and will build it irrespective of any township zoning ordinance. What that means is that the county has unfettered discretion to cite any land use it wants, despite the prohibition of doing so under the statute and or Herman. They are irreconcilable. You cannot allow a county to say, we'll tell you what we're going to build, we're going to tell you what we're going to use it for.
Well, there's some limitations, right, on what's the proper county building, right? What's a proper function? They can't just do anything they want, right? They can't build a nightclub, could they?
Well, I don't know the answer to that because the county has argued they get to determine the normal use of a county building. So is it a building owned by the county? That seems to be the end of the county's analysis. As long as it's a county-owned building, we'll decide where to build it, what to call it, what the normal use is, and because of that, we now have priority over any conflicting ordinance. That means...
Say we don't determine that the answer is all or nothing, but we come up with some reasonable interpretation. Let me ask another question. You know, by comparison, we can think of the statute that governs schools, right? And the superintendent, state superintendent, having a lot of power over the building and construction of schools, which extends beyond the buildings themselves to all of the surrounding property, right? And the athletic fields and so on and so forth. And the local zoning authority has nothing to say about that, as far as I could tell. Isn't there perhaps a middle ground interpretation that would mean that the county gets to cite a building which includes an outdoor land use, as long as it's part of the natural, normal use of the building, I suppose? You know, not up to them, but up to the court. But that the county can't then go on and develop myriad outdoor uses, whatever adjective we decide to use, whether they're ancillary or subordinate or secondary or accessory or whatever, you know, whatever adjective you want to pick. Why is that not a reasonable interpretation?
Well, I think it is a reasonable interpretation, but there's a difference between, say, the revised school code and the sole and exclusive jurisdiction language included in the statute.
Well, I agree, and that's why I said we wouldn't interpret it to be the same power that the superintendent of schools has.
But I think that this court has already made that interpretation that actually works, and that is whether it's ancillary and indispensable to the normal use of the building. The problem with that argument is that you can't then allow the county to expand or determine in all instances. In other words, as this court said in Herman 1, it's got to be a case-by-case analysis because it involves not only an analysis of the building itself, the uses of that building, and then whether those accessory uses are ancillary and indispensable to the normal use of that building. The problem with this case is that the county is arguing that we're going to determine what the normal use is. despite the fact that
I mean, you say they're going to determine, obviously that's a question for the court to consider, right?
Well, what the county's arguing is that the legislative body, the county commissioners, they get to determine the normal use of the building. That's what they've argued. And you shouldn't interfere.
If we start with the question of whether this is a normal use of the building, does the township lose?
No, I don't think so, because you still have to arrive at the ancillary and indispensable. So when you get to ancillary, is it an ancillary use? Is outdoor shooting, something that was conducted on the property without a building, now become the ancillary use on the property? I would argue that it still is the primary use, the way it was before, the way it is now. It is the primary use.
What's the normal use of the building?
Well, the normal use of the building is determined today, at least, by the county, as shooting range building.
Well, let me give you your opportunity. What do you think the normal use of the building is?
I think it can be whatever the county says it's going to be. And then it's up to the courts then to define whether it is or not. Let me give you...
You just disclaim taking any position on that?
No. What I'm saying is that has to be...
Does your client have a position on the normal use of the building?
What we've said in our brief is this is not a building that is uniquely situated for counties. This could be a picnic pavilion, a pole barn. Let's call it a pole barn. I'm happy to call it a pole barn. We can call it a various number of uses that may...
So is there no normal use of this building?
Well, as determined by...
It can be used for different things, but...
Yes, it can be used for a myriad of different things.
It's kind of abstract, right?
Yeah, well, yes, to some degree. And that's why we've argued that this is not a building or structure that is in those class of buildings or structures defined by the CCA. This isn't a clerk's office. This isn't a jail, a courthouse. This is a pole barn structure.
But counties have other buildings beyond a jail and a courthouse, don't they?
I presume that they do.
I mean, some counties own airports, which is why that makes it an interesting question, right? Whether
Yes.
they're allowed to cite the airport.
Yes. The problem with this case is particularly, and I think that...
What would we do in the airport case if they decided to build an airport and they didn't have a structure somehow? I don't know how you do that. Maybe they have autonomous airplane flying now or something. But then they built the hangar later. Would we be in the same situation that we're in this case?
You could be, but I think it still requires an examination of the primary land use and whether they have the authority to cite a land use. In normal circumstances, too, this is not an issue. It just happens to be an issue because the county has refused to comply with the township zoning ordinance.
Do you agree that they get the normal use of the building?
I'm sorry?
As a general rule? They get the normal use of the building? That's what the
They get it.
statute, they build a building and they build a prison. The normal use is to house prisoners. They can use it for that purpose, even if the neighbors don't like it.
Yes. I mean, they just located a jail in Wexford County. And here's where the problem is. This jail up in Wexford County was plopped right on adjacent property. It was all zoned residential, and it's plopped right in the middle of residentially zoned areas. That's why I'm saying that you have to be very circumspect here with the CCA and the very limited authority, because it upsets the normal planning and zoning process. And the county's argument here...
I mean, that's sort of the point, whatever the scope of it is, however narrow or wide, that's the point of it, right? It
The point of
overcomes
it-
the local limitations that a lot of reasonable people would say, I don't want a jail in my backyard. Can't really blame people for that, right?
Right. You're absolutely right. But here we're citing a land use. There we're citing a building. And those buildings are unique, at least in the list of buildings under the CCA, to the county's authority to do.
The muddle I get into is, but the building always has a use, at least one.
Yes.
Sometimes they have multiple uses.
Yes.
That's why I asked you the question, do they get the normal use?
Well, tomorrow they change the normal use to a concession stand and they put a racetrack in.
Well, it has to be a
What's the
governmental.
primary
It has
use?
to be a governmental. I mean, they have to have some. I thought there was some baseline that everyone agreed that they had to have authority under the statute to perform that function.
Well,
I mean,
the function-
can they open a 7-Eleven?
Well, presumably, if it's a county building.
So you think their position is they can do whatever they want?
Yes, they've argued as much. That's right.
If the building had been built first, and then the outdoor range second, can they do that?
I think it would still be subject to challenge on the same basis on the primary versus ancillary land use issue, because the land use is predominant in terms of the analysis even. I know
If they used the building for 5 years and then built the range.
So I guess it depends on what the building was used for, but so now
For training.
So they use a building, well, take for instance the classroom building. That's a perfect example, right? Let's suppose they converted the classroom building that was the subject of this case, this court's case in Herman 1. Let's suppose they just put up now pop-up windows on the outside, so they didn't ever have to leave the building. They can have classroom training in there, and now they just pop out the windows and start firing from the building itself. In that instance, when we're talking about the range, the primary land use still is outdoor shooting, and they have no authority to cite those land uses. And that's why I'm suggesting that it's irreconcilable with this court's opinion and the statute, because their power to cite land uses is non-existent. And that's exactly what has occurred here. And if you allow the county to build what they want, where they want, call it what they want, you have subsumed the entire statute, the entire case, and the statutory limitation. If you have any more questions, I'd be happy to.
Just a quick question. As I read the Court of Appeals opinion, and maybe you can help to clarify it, it doesn't appear that you can have if you read the Court of Appeals opinion, am I able to even have a firing range?
Yes, and so this gets back to what I think gets lost in this entire argument. The township is not saying we prohibit firing ranges. The township is saying if you want a firing range, you have to comply with our zoning ordinance.
Is that doable? The argument has been made that it's impossible to comply, so they really, in effect, can't have one.
Well, they may not be able to have one there, but the township has included a provision for law enforcement training facility. So yes, there is a permitted land use by special use permit. They have not applied, to my knowledge.
But under this, let me just kind of expand this discussion a little bit. So let's just say the county had built the police academy there, and you have a beautiful academy, you have the training sessions, you have the buildings, you have a pool, you have all the things that you would need. Under the Court of Appeals opinion, if you had constructed a full academy, would they, under the analysis that we're doing and under what the Court of Appeals said, if we weren't to alter that opinion, would you be able to then construct a firing range at the actual academy?
You may be able to do that in that context, because the analysis comes down to, at least on the ancillary and indispensable issue, comes down to is it an ancillary land use? And we deal with this in zoning ordinances all the time, right? We have, say, for instance, residentially zoned property. You can use your property for building a house and locating a single-family dwelling there. You also can use it for accessory purposes, like building a shed. Why? Because we have outdoor tools that we'd like to store. That is an ancillary or accessory use to the residential use of that property.
Can they build
Council,
a
can
county
I-
hospital?
I'm sorry.
I'll defer to the chief.
Well, I guess I wanted to interrupt both of you and ask if you would consent to having the other counsel speak for a few minutes. His time is rapidly running out, but I don't want to interfere with your questioning. Is that okay with you, Justice Bernstein?
Sure.
Thank you very much.
I think Justice Wilder had a question, though.
I'm deferring to the chief.
Oh.
He was okay with it, too.
Good morning. May it please the court, J.R. Paul appearing on behalf of the plaintiffs, Appellees in the Herman case this morning. This is my client's second appearance in this honorable court in this litigation, which started in 2005. From the beginning, this litigation has been about the county's desire to cite and engage in the activity of outdoor shooting in violation of the township zoning ordinance on property located less than 2 miles from my client's farms, businesses, and homes. The client's desired activity and land use, which is the primary use, is the same today as it was back in 2005 when the case started, namely outdoor shooting. The only thing that has changed on the property since this court's opinion in Herman 1 is the county's erection of the open-air pole barn shelter on one of the gun ranges. The structure was not part of the original plans for the training facility in 2005. It wasn't proposed until 8 years later in August of 2013. The county erected the structure for the sole purpose of resuming outdoor shooting without providing notice to the township or seeking permission from the circuit court. The sheriff's office subsequently conducted firearms training on 8 occasions on the ranges in violation of the injunctive order entered by the circuit court after remand in 2008. The county's conduct once again thrust my clients into costly and burdensome litigation, seeking enforcement of the injunctive order through contempt proceedings in the circuit court. It is our position that the facts of this case are distinguishable from the facts of the Bradley Estate opinion with respect to the attorney fee issue under the contempt indemnification provision of MCL 600-1721. The plaintiff in Bradley Estate attempted to recast a tort claim that had been dismissed by the circuit court on governmental immunity grounds as a civil contempt petition. In this case, we have a clear violation of a permanent injunctive order. There's no arguable underlying tort claim in this case. It was simply a violation of an injunctive order in an effort to enforce the injunctive order through contempt proceedings. As outlined in Justice McCormick's dissent in Bradley Estate, contempt stems from a violation of an obligation owed to the court itself and serves to protect the power of the courts rather than private rights. The county's violation of the injunctive order in this case was a violation of a duty owed to the court, did not arise from any tort duty to another private citizen. I note in the majority's opinion, footnote 25, the court suggested that it did not necessarily disagree with Justice McCormick's opinion regarding the nature of contempt, but it viewed the case before it as presenting a more nuanced issue, namely an attempt to recast a wrongful death claim that is barred by the Government Tort Liability Act as a claim for civil contempt. Our position is this case doesn't present the same type of nuanced issue that was before the court in Bradley Estate, given that we're dealing with just a violation of an injunctive order. Given that the case is distinguishable from the facts of Bradley Estate, we believe the Court of Appeals appropriately vacated the trial court's order regarding attorney's fees. I don't have anything further unless the court has questions for me this morning.
This is a statute.
I was going to return to Mr. Homier, and perhaps you have some
I'm just
questions.
going to ask if the statute specifically authorizes attorney fees.
Not specifically, but case law interpreting the statute does provide that attorney's fees can be awarded in connection with contempt finding under MCL 600-1721.
Was that case law correct? Talking about plumbers? You're talking about plumbers versus pipe fitters?
That may be one of the opinions. I believe there are others, Your Honor.
Okay, thank you.
Counsel, I'd like to ask a question. I realize this is a very complicated case and we're getting into legal terminology, but if you could help me to understand, since you kind of are on the ground with your clients, what is the impact of the gun range upon their neighborhoods and their life experiences?
Well, it's a significant impact, Justice Bernstein, and thank you for asking that question. The property in question is zoned primarily agricultural, which allows farms and residences. One type of rifle utilized on the ranges can fire a bullet 2.4 miles. There are children's sports fields within 1 mile of the ranges. The ranges are within 2.4 miles of schools, within 1 mile of over 50 homes. There are migrant worker residences within 1,500 feet of the gun ranges. And my clients themselves own farms, businesses, and residences in close proximity to the ranges. As you can imagine, having an active shooting range facility and active firearms training produces noise, creates fear and anxiety, causes concern to my clients over the viability of their businesses. They rely on people coming to their farms. Their orchard is an important part of their business. And obviously, a family might think twice about wanting to go visit a farm or an orchard when there is active shooting going on less than a mile away from the location.
How noisy is it?
It's extremely noisy. My clients, despite the claim about the sound baffling on this new structure, my clients were able to hear the shooting once it resumed back in September of 2013 and actually made complaints with the county and the sheriff's office about the resumption of firearms training because they weren't aware that the building, the structure was being erected. So they were obviously caught off guard to hear shooting going on again. So it is noisy and disruptive.
And what are the hours that they use?
It can be, I think, all hours of the day, including at night. I think that's one of the things the sheriff's department does is actually train after nightfall. So it can go on any time of the day.
So does it also occur on weekends?
That I'm not certain about. It may, but I don't know the precise answer to that question.
But it does happen during the day and the evening as well.
I believe that's correct, Your Honor.
Thank you.
Any further questions? Are there any further questions of Mr. Homier? Would you please come back up here? I interrupted the exchange, I think. Justice Bernstein, Justice Wilder, any other justice? Would you have any questions?
My question was with regard to a county airport or a county hospital. Could the county site a hospital?
Yes,
Could they then site a helicopter pad?
probably. Yes. Because a helicopter pad is not the primary land use, right? The question is, I suppose at a hospital, not that you would ever do this, can you site a gun range too on that same property? Probably not. So, because those are not accessory or ancillary and indispensable to the normal use of that building. The problem here is we flipped the sort of the ancillary and primary use, and the Court of Appeals understood that in terms of that priority of uses that has to be examined as part of that test. They did that, which is why they used the term. We have the tail wagging the dog here. There's no dispute that the county wanted to cite a land use. And let's not be mistaken about this issue. The county sheriff never cited safety and noise as a reason why they built this building. What he did say is because we wanted to get around the restrictions of Herman 1. That's what he said. Thank you.
Thank you.
Thank you, Counsel. You've got 5 minutes left.
Thank you, Your Honors. 3 quick points in rebuttal. First, we believe that plaintiffs are blurring the distinction between the normal use of the building and the land use. Those are 2 separate uses that must be analyzed separately, and for purposes of this case, it's the normal use of the building that prevails. Defendants are not seeking...
Is the normal use of the building a land use?
Herman held that we have the authority to cite a building and whatever attendant normal uses come with that building. And Herman said that the normal use only extends to the actual uses. That's Herman at 370. And those are only uses that are permitted under the law.
It's a long answer. It still doesn't really answer the question. Isn't the normal use of the building a land use? Or is it something else?
Yes, it is, because the building's cited on the land, sure. Okay. And here, we haven't heard from plaintiffs an analysis of the normal use of the gun range building. That was a determination that Judge Duane made, was to facilitate the safe and quiet outdoor firearms training of Berrien County sheriffs. We think that's where the analysis has to start, is what's the normal use of the building. My second point is in response to the Chief Justice's example of a concession stand and plaintiff's counsel's example of a hut to collect money. Neither of those uses would be permitted under Herman, so I don't think this case is in the bucket of the cases of the sky is falling and counties can do whatever they want. The reason those buildings wouldn't survive scrutiny under Herman is because the normal use of a concession stand is to sell food or drinks, not to allow an exhibition space or a racetrack or a golf course or whatever it might be. The normal use is to sell food. Similarly, the hut to collect money, the normal use of that is to collect money. A gun range wouldn't be ancillary to that. A racetrack wouldn't be ancillary to that. An airport wouldn't be ancillary to that. So we don't think that those examples should drive the conclusion in this case.
Well, what if instead of putting up a concession stand, they put up a dugout? Now, can you build the whole stadium for a baseball team?
No, so I guess the dispositive question then would be, what's the normal use of the dugout? And I would say that it's to protect people from the weather or to give them a place to sit. But that's the first step in the analysis, and plaintiffs want to look at the ancillary or indispensable use of whatever's adjacent to the building before looking at the normal use of the building. My final point in response to Justice Bernstein's question about where this is cited and its impact on county residents. Defendants are fully aware of the impact of a gun range on county residents, and we're extremely sensitive to the fact that this isn't necessarily considered the most desirable land use. But the court should be mindful of, and plaintiffs should be mindful of, the fact that this gun range and the gun range building are sited on a landfill, which is not necessarily considered a desirable place to begin with. The issue of noise has not been litigated below, whether the gun range and the noise that comes with it falls within certain zoning restrictions has not been developed. There's no record on that. And if a county can't cite a building like this at a landfill, then where would be a better site? The county knows it needs to train its sheriffs. It needs to comply with state-mandated firearms training laws, and this is where it chose to cite the building. So with that, barring any further questions.
Please, Justice.
Well, Mr. Riley, we had what I thought was an interesting discussion at yesterday's arguments concerning the scope of the justum generis argument. And I look at the statute here, 46.11, and it seems to be structured along the same lines, referring to a courthouse, jail, clerk's office, or other county building. I think Mr. Pohl makes an interesting argument in his brief focused upon that argument, in which he says that while the gun range building here may be under ordinary understandings of the term county building, a county building, when it's aligned with these other more specific illustrations of a county building, a courthouse, a jail, a clerk's office, it may not be the same kind of county building that's referred to in this language. In other words, these county buildings that are laid out, the litany of which is laid out in 4611, all are more traditional structures with four walls, with plumbing, with electricity, with all the accoutrements of these kinds of buildings. And the gun range building is not such a building. What is your response to what I think is Mr. Pohl's interesting argument that if you apply the traditional understanding of justum generis, the county building here is not a county building of the sort laid out in 4611?
Sure. Two points in response. We don't believe that justum generis, and I probably just butchered that Latin word, applies here because the statute at issue has been held to be unambiguous. And the statutory tools of construction don't apply where the statute is unambiguous, so we don't think there's a need to resort to an interpretive aid in this case. Second point would be that the buildings specified in the statutes, jails, courthouses, clerk's offices, don't necessarily share similar functions. As Judge Duane noted in his opinion, the purpose of jails is to keep prisoners in. The purpose of a courthouse is to conduct judicial functions. The purpose of a clerk's office is to keep records and perform other administrative tasks.
Well, of course, these buildings can be distinguished in various ways. They're not identical, but they do share in common the traditionalism, the traditionalist kind of structure that we tend to think of as a building. As I say, four walls, electricity, plumbing, whatever else, seems to be descriptive of the kind of building we think about as a courthouse, an administrative building, a library. They all are different kind of structures, at least arguably, than the structure that's in dispute in this case.
Yes, they certainly all serve the purpose of...
It's not the purpose, it's the type of structure we're talking about here more than the purpose. Of course, every one of these buildings has a different purpose. A jail has a different purpose from a clerk's office, and a clerk's office has a different purpose from a county office building, but it's the commonality of the kind of edifice or structure they are that's in dispute here.
Yes, understood that the gun range buildings do not share HVAC, indoor plumbing, bathrooms, elevators, et cetera, like those other buildings. We don't believe there's any statutory support for the requirement that a county building contain certain types of requirements. That's why the legislature used the phrase other county buildings. So we believe the legislature contemplated that other types of structures.
Or other county buildings, does that refer to a freestanding and independent understanding of a county building, or does that refer, as the premise is when we apply justum generis, it refers to the kind of county building described in the prior litany of listings?
Yeah, yes, that's what that method of interpretation does suggest, and again, we don't believe that applies given that the statute is otherwise unambiguous.
I didn't know that ambiguity was at issue here so much as whether or not this was a county building that was described in general by the listing of terms laid out in this provision.
Understood and well taken, Your Honor.
Okay, thank you. Any other questions?
Does that make sense, Counsel? I mean, like, just from a practical perspective, I mean, does that make sense that you could just put down some pieces of plywood and consider that to be a building?
The legislature granted counties the authority to cite buildings, and this court in Herman recognized that the only restriction on that authority is that a building comply with the requirement at law that the building be located at the county seat. That's not at issue here, so we don't believe that the legislature imposed any further requirements on counties.
And you believe that the legislature, when they use the word building, kind of allowed for this to kind of subsume your definition, which is really, I mean, from all kind of layman's perspective, would not really be a building, is it?
We believe that it is.
I mean, I could go with my clerks right now and put some stakes in the ground, and we could have created this building.
We believe this particular building is a bit more functional than that. It does have a large concrete slab, 43 by 20 feet. It's got 8 poles that are anchored 4 feet into the ground to support a permanent roof structure. Under the dictionary definitions of the word building, as those have been applied in the Ali and the Pierce cases, we believe that this structure too qualifies as a building under whatever dictionary definition of building the court would prefer to
What is
employ.
the specific, what actually happens inside this building? We understand that it's adjacent to a gun range, but if I were to go into that building, what would I specifically find within the confines of that building?
So when the building is being used, there would be sheriff's deputies using their firearms, firing outside of the open side of the building out into the gun range. And that would be from various positions, prone position, standing position, doing what sheriff's deputies need to do to comply with the state-mandated firearms training protocols.
Okay, thank you, Counsel.
Thank you, Counsel. The case will be submitted. We appreciate your arguments.